Joining us now to discuss the Derek Chauvin verdict is C.K. Hoffler, the president of the National Bar Association and CEO of the C.K. Hoffler firm. Welcome to the Black Report, C.K. Thank you for joining us.
Well, thank you.
Okay, so let's jump right into it. Today is an incredible day. Hope was high for a conviction of the highest charge, but most of us were afraid to allow ourselves to do just that. Hope. Was the verdict what you expected?
It was what I expected. It was what I prayed for. But there was part of me that just felt, please don't let the narrative be that there is a non-guilty verdict. I prayed for this. I thought the evidence supported a conviction on all three. Quite frankly, I thought the evidence would have supported a verdict of guilty on a first degree under Minnesota law. But I do understand that second degree murder, second degree manslaughter, and third degree murder is what the prosecutor and what the district attorney or the attorney general felt was appropriate. And so it was what I expected. But as an African American, as president of the National Bar, and being a lawyer for almost 34 years, I know, and being a trial lawyer, I know that juries can be unpredictable, even with a mountain of evidence to support a conviction or to support, so I had that sigh of relief because I just was, it was getting kind of tight there for a moment for all of us, for the country, but not just the country, for the world. Everybody is watching this because, my goodness, if there's not a conviction with these facts, with this evidence, what in the world would it ever take to convict a police officer?
Exactly.
So I was relieved. I'm not saying that this is the end all be all. This is step one in a multiple step process, because as Vice President Kamala Harris just said, a measure of justice is not equal justice. You know that. A measure of justice, which this is a measure of justice without a doubt. But it is not equal justice, because there have been literally thousands of George Floyds we know in our community that we've seen. And I say that because, as president of the National Bar, all of my members are the ones on the front lines trying these cases. Every single last one of the high profile cases that we see are being led by National Bar Association members. But even before it was in vogue to have these cases, mainstream, media looked at these cases. My members have been trying these cases, and it's very, very, the civil part of these cases. And they've been fighting for district attorneys, attorney generals to take that step to indict, to have an indictment, to put it forward and to try these cases. And it's been very, very difficult. So this is a step for justice, but it is not equal justice. There's so much more that we have to do.
Agreed. CK, thank you so much for joining us. And you aren't the only one. So many people online felt the exact same way, that there was enough evidence for a first-degree murder charge as well. But I'd like to get your thoughts on both the defense and the prosecutor's performance in this trial. And if you wouldn't mind, can we start with the defense?
Well, I think the defense, if I start with closing statements, way too long. I think the defense overplayed his hand. This reasonable policeman, well, there was nothing reasonable about this policeman. So when you use reasonable and Derek Chauvin, knee on the neck for 9 minutes and 29 seconds, and what we saw and we trust, even if we didn't trust our eyes, saying reasonable over and over and over and over again begged the question, you talking about someone else? So I think the defense overplayed its hand. I think the worst witness of the entire trial was their main expert. He was just, I'm a trial lawyer, so I would dare say that if I ever put up a witness who was just making up stuff as he went along, this carbon monoxide theory, no evidence to support that. He talked about every single thing else, but the knee to the neck for 9 minutes and 29 seconds. You see, that to me defied logic. It defied common sense. And it was really borderline offensive. You're talking about someone who died before our eyes, and you come up with, he had a bad heart, he ingested drugs, his, carbon monoxide, the carbon monoxide was what, all of these things were not credible. And so I think that I felt that was part of why the verdict was what it was. The other part of it was just the facts of the case. We could see what happened. We saw George Floyd being murdered before our very own eyes. Those are bad facts for any defense. You can't pick your facts if you're a defense lawyer, but I think you can work with them. And I think that he overplayed his hand, and certainly there could have been a different strategy in terms of trying to find reasonable doubt. And then there was a misstatement of the law. You see, this is the thing. When you're a juror, and I know this as a trial lawyer, if you misstate something and look at a jury in the eye and misstate the law, which was when he said that the prosecution didn't prove its case because they had to prove he intended to kill George Floyd. I don't know if y'all remember that. And it might have just been like, man, that was bad, and more bad. That wasn't the law. So when you start saying that, just think about how you feel. If someone makes up stuff and is there and all the eyes of the world are on that person, what else have they made up? Can we trust that person? And so I think it was just a combination of things. But let's just talk about how persuasive and convincing and professional the prosecution was in the presentation of evidence. They did something that was great. They had not just fact witnesses, meaning witnesses who were there that could talk to what they saw. They had not just one, not two, not three, 4 medical experts. They left no stone unturned with the evidence. Medical examiner, pulmonologist, it's sort of like, oh, you don't believe him? How about this one? You don't believe that? What about this? Oh, you didn't? Oh, because you're just saying that? Yeah, bam, we got you on this. That was the approach from a forensic medical standpoint. And then the most important piece of evidence was that video. Not 8 minutes and 46 seconds like we believe, but 9 minutes and 29 seconds of watching someone being murdered. Another faux pas that the defense made was focusing on that 16 minutes before the 9 minutes and 29 seconds. Why? Because George Floyd was compliant. You said jump. He said, how far do you want me to jump? You said go in the car. The only time he wasn't compliant was when he said, I have claustrophobia. Please don't put me in this little car. But everything else, sit down. He sat down. They treated him like a dog, and he complied. And so the message there was, Black man, if you comply, you still gonna get killed. But in focusing on that 16 minutes before, bad strategic move, because it showed that George Floyd kind of was like, please don't do this. And by the way, did he ever know why he was killed? Because I didn't hear anything about a counterfeit $20 bill.
Exactly.
Did he ever know why the life was being crushed out of him? Did George Floyd ever know? Because surely it couldn't be for a $20 counterfeit bill, allegedly. Don't even know if it was his. But surely it couldn't be that, because that doesn't call for someone having their life taken from them in that painful way. It was painful. And we saw that. So I think, the prosecution, when they said, trust your eyes, they were speaking truth to power.
Exactly.
Trust your eyes. And in the process of laying a methodical case, it wasn't just that, it was those 3 pockets: fact witnesses, medical witnesses, and by the way, those police officers, the chief of police saying, excuse me, we are in this industry. He deviated from the training, he deviated from the standard, he was not ethical and he was not professional, and it was uncalled for in the methodical way that those officers broke down when he should have stopped. You see, that's a wrap. Because when people, they stand together, law enforcement, Black, white, everybody, sometimes they stand together in these cases. And when they broke ranks and said, look, no justification whatsoever. We're trained better. This is not the way it's supposed to be. There was literally nobody other than a doctor making up stuff who basically supported what Derek Chauvin did.
Wow, there is just so much here. I'm so glad and thankful that we have your insight. Police officers have, I don't know, something like a 90% acquittal rate at trial. And you probably just touched on a few just now, talking about what the prosecution had in their bag. But are there any other specific distinctions you can think of between this trial and essentially all the others?
I think the video, the length of the video and the persuasiveness of the video, because you might have because it's only recently when people started videotaping this, and that's a real recent phenomenon with the smartphones working and all that. Prior to that, people might have videotaped a little bit here, a little bit there, but that's a recent phenomenon. I think that was the most compelling piece of evidence, and they used it in a very compelling way. They dissected that video, scene by scene, minute by minute, second by second. Okay, so tell us now, they said to the witnesses, when should Derek Chauvin have stopped? And they could go to the video right here, right now. And by the way, he kept on for about 4 minutes. He wanted to, it was so personal. It is as if he wanted to make sure he killed this man, this black man. He was determined to do it. And no matter what George Floyd said, it was a wrap. And when he couldn't breathe anymore, he continued. When he was crying for his mother, he continued. When he didn't have a pulse, he continued. When the ambulance people were there, he continued. That speaks to something different. And that's why I believe he was convicted of all 3 of those and could have gotten that 4th one, I believe. I understand why there was that call that was made, because under Minnesota law, sometimes as a lawyer, you have to deal with the law as you have it, as you get it, as you find it. You can't change the law in your case while it's ongoing. There may be changes as a result of your case. But while your case is ongoing, you're there, you're in it to win it. And what these prosecutors understood was 2nd-degree murder would get him 40 years as a maximum. 3rd degree would get him 25 as a maximum. And even the little throwaway one, which is like, your back pocket in case everything fails, which is sort of like negligence almost, culpable negligence, even that one carries a maximum of 10 years. So when you add it up, it could have been 75 years. So in effect, if they won on any one of those counts, it was going to be really bad for Derek Chauvin. But of course, I knew that once the guilty verdict was read on the most severe crime, the other ones were going to follow suit, because some of the same elements of 2nd-degree murder under Minnesota law were for a conviction of 3rd-degree murder under Minnesota law. The first 3 elements were about the same. And then the last one, well, that was just a dead giveaway, because if you could meet the burden for the others, surely you could meet the burden for culpable negligence or some, manslaughter, some kind of lesser, which if they had just convicted him on manslaughter, I would have been some kind of upset. I can tell you that.
Yeah, we all would have been, that's for sure. Man, you are bringing us the facts today. That is for sure. We appreciate that. But do you think the U.S. legal system needs some revamping?
Absolutely, positively, without a question.
Oh, okay.
It needs
Strong
revamping.
answer.
I just, because I have to say it like I'm going to call it like I see it. I've been in this industry for almost 34 years. I've been Jesse Jackson's lawyer for almost 33 years. And so I've seen, but I've done corporate, commercial, opioid litigation, tobacco litigation, employment litigation, catastrophic injury cases. So I've seen a lot, always in the private sector, but yet I have always had a civil rights perspective, because I had the honor and privilege of being counsel to Reverend Jesse Jackson. So there's really not a major civil rights issue over most of my career, with the exception of maybe 6 or 7 months, that I haven't seen and haven't looked at from the legal aspects. Without a doubt, the system needs overhauling. Without a doubt, there needs to be a passage of the George Floyd Justice and Policing Act. It's not going to be enough. We can't stand on any laurels. By the way, nothing's going to bring back George Floyd. That's what the family needed. It's not going to happen, but accountability is a good second. But the work that needs to be done to reform the system is very significant, and the passage of federal statutes, as well as working on a state-by-state basis, that's going to be critical.
Ms. Hoffler, you are effervescent, passionate, our favorite kind of guest. Thank you so much for joining us here at the Black Report. You are welcome back anytime.
And let me tell you something, it's an honor to be here. I just want you all to know that. So you all call me, I will be professional. I will look at my schedule for 10 seconds. And be very, and I do have a crazy schedule, but I have to tell you, I really appreciate what you all do, how you report, and your perspective. And it's much needed. So anytime I can lend a hand, I would love to share a perspective or bring my members to you. Because we have the best and the brightest, make no mistake about it. When you see Ben Crump, you see the National Bar. When you see Chris Stewart, you see the National Bar. When you see Lee Merritt, you see the National Bar. See Darrell Parks, Lonita Baker, they are all leaders in the National Bar Association. Thurgood Marshall was, Charles Hamilton, all of them. So
we will definitely take you up on that offer.
Absolutely.
Thank you.